Welcome to the second session for the day. In this session, we'll be discussing the topic of community-based restorative justice. We have the honor to have amongst us Professor Michael O'Connell, Secretary General, World Society of Victimology, Professor Sarah A. Simons, Member, World Society of Victimology, and Dr. P. Madhava Soma Sundaram, Professor and Head, Department of Criminology, Manonmaniam, Sundaranar University, Tamil Nadu. We also have amongst us Ma'am Professor Dr. Kavita Singh, who will be moderating this session. Ma'am is professor at NUJS Kolkata. Before joining NUJS, Ma'am has been associated with the University of North Bengal and Kalyani University as a lecturer. She is also a visiting faculty at Central Detective Training College, Central Bureau of Investigation Training Center, West Bengal Judicial Academy, and Swami Vivekanand State Police Academy, Barakpur. Ma'am has authored 2 books and has edited more than 5 books and has 35 research publications to her credit. Her research interests include criminal law, criminology, victimology, and family law. Ma'am, I welcome you to this session and invite you to start with the deliberations for this session. Over to you, ma'am.
Thank you, Shruti. At the very outset, I would thank Professor Bajpai and the organizing team for choosing me to moderate this session. It's my pleasure and honor. And the panel discussion would be moderated by me, and the time is more important because we will have to resort to the time to complete the discussion on the scheduled time given to us. So for which every speaker will be given 10 minutes, and before completion of 10 minutes, maybe 5 seconds or 10 seconds before, I'll just send a reminder. I'll call upon and send the reminder. And so each one of the speaker has to resort to time. I'll introduce the topic at the beginning, and then one by one the professors would be invited. Community-based restorative justice. What do we mean by community-based restorative justice? It is another way to resolve the conflict, the misbehavior, and the wrongdoing of the offender. And it has actually impacted not only the victim, but also the society at large. It creates a responsibility to on the system, that is the criminal justice system, to have a proactive involvement of the victims, and the offender takes the responsibility of causing harm to the victim and the society. Now, in doing so, the community would be benefited, or would get solutions could be given in such a way that we prepare the reconciliation and assurance given to the victim. In a manner, actually, what happens is that restorative justice, there is a five R's to be taken care of when we are understanding community-based restorative justice. First is relationship, the respect, responsibility, repair, and reintegration. The 3 core elements of restorative justice are interconnected concepts of encounter, repair, and well-being, and the wholeness of the victim, offender, and community members that experience. So here, if we talk about in particularly in the Indian context, what happens, we have very little scope of restorative justice in our statutory law, or laws which we have, or the procedures which we follow. In the CRPC, we have only section 320, where compounding of offenses are there, and in course of that, the victim is given little assurance that the accused will be the victims will be taken care of by the accused for the compensation and etc. But in the Juvenile Justice Care and Protection Act, we have a provision, section 18, which talks about that a child in conflict with law will be sentenced, where the court is going to the Juvenile Justice Board is going to direct the child to participate in group counseling and similar activities. The second part of it talks about that the Juvenile Justice Board is going to order the child to perform community service under the supervision of the organization or institution or specified person or group of person identified by the board. Now, we have to go a long way in India to strictly have a community-based restorative system in place. Taking from there, I would just call upon our first speaker, Professor Michael O'Connell. Good morning, good afternoon, sir. Welcome to this first session. Professor Michael O'Connell is a consulting victimologist and a renowned international guest faculty and lecturer across the globe on victimology, victims' right, and victim assistance. He was the first commissioner of victim rights, South Australia, and while serving as a police officer, he was the inaugural Victim Impact Statement Coordinator. Intentionally, he is a life member of, internationally, he is a life member of current Secretary General of, for the, Secretary General for the, for the World Society of Victimology, a Vice President of NGO Alliance on Victim Prevention and Criminal Justice Administration, a member of the International Network supporting victim of terrorism, White Ribbon Ambassador, and patron of the Love, Hope, and Gratitude Foundation, and foundation of the board member of Victim Support Asia. As an expert, he has participated in several UN projects on victim rights, including rights of victims of terrorism and victims of sexual exploitation. Restorative justice and other justice matters. In 1995, he was awarded the Australian Police Medal, then in 2017, in recognition of his tireless campaign for victims' rights and contributions to criminal justice policy. He was a member of the Order of Australia. We also have the honor to have Professor Connell as one of the board of advisors for the Center of Criminology, Criminal Justice and Victimology, which has been set up by Rajiv Gandhi National University of Law, Punjab, for advanced research training, policy analysis, and consultancy in area concerning criminology, criminal justice, and victimology. Professor, over to you. And please adhere to time, 10 minutes.
Thank you. One of the advantages of speaking at an international conference is that you get to hear your eulogy. You get to hear the nice things that people would say about you at your funeral. So I thank you for that wonderful and very pleasant and informative introduction. So when crime happens, there are two victims. Blackstone, the famous English jurist, said that the victims are the actual people who are harmed, as well as the community or the public at large. And in those countries such as India and Pakistan and elsewhere, just bear with me, I'm going to stop my video for a moment because we have an electrical storm here and I've got a warning on my screen to say the connection's not very strong. So if you lose me, I will still keep talking so we don't waste time. So those countries that adopted the British common law, so India and Pakistan to a certain extent. More recently, they've had two systems running. Australia, where I am, New Zealand, the United States, Canada, and so on. Those countries that were colonised by the British adopted a system whereby predominantly the early law recognised those two victims, but over a period of time, and particularly since the 18th century, we have seen the victim gradually be whittled away or have his or her role diminished, so that they are, as many people said during the 1970s, the forgotten person, or they are regulated to be merely a witness for the prosecution of the state, that is the public at large that the state represents. Now, there have been various approaches to try and reform justice systems. So some of those are add-ons and reforms of the common law system. For example, in my home state of South Australia, in some cases, victims can have their own lawyers to help amplify their voices, to give them a stronger role in the decision-making process as a case progresses through the charge, assessment, the prosecution in criminal proceedings, and even in sentencing, and in some circumstances at parole hearings. There have been other approaches to try and modify the system. There are some who have argued that we should throw the system away and begin again. Among those who have argued initially throw the system away were the Melamites and other deeply religious people who began to revisit some of the early justice systems that today we would fit under the broad umbrella of restorative practices. And in those, what the Melamites called the 10 commandments of restorative justice, the commandments proclaimed that the victim should have a role, the community should have a role, and the accused, the offender, should have a role in terms of reflecting on what has been done, but mapping out a future for themselves, recognising often that the offender, the victim, and the public at large all have to continue living together, coexisting together. There are others who have argued that restorative justice can augment the existing system, and we see many programs that fit that definition, whether it be in youth justice, such as family conferencing in New Zealand or here in South Australia, or whether it be restorative conferences, has happened in some parts of the UK in regard to either alerting the now guilty offender of the harm that he or she has done, and in some circumstances before a person is released to parole, that is back into the community to complete their sentence. Now, having planted that seed very quickly, the question that begs an answer during this session is, what is the value of restorative justice for victims and for the public at large? And for that purpose, let's imagine for a moment that you have a backpack, very much like I have here in my hand, and I become a victim of crime. At the moment, it is empty, but as I become a victim of crime, I become angry, so my anger goes in the bag. I become frustrated by the fact that I've become a victim of crime. I began to experience a whole range of emotional responses, all of which go into this bag. And over a period of time, those immediate effects, unless they are tackled, become a burden that I carry on my back from now on. When I reach the criminal justice system, I come in contact with the police and often they treat me ambivalently. So that puts another weight into this backpack. Then the prosecutors don't want to listen to what I have to say. So that puts another weight into the backpack. And nowhere in the common law system is there a means by which I can, in the context of procedural and also distributive justice, take that load out of my bag. Whereas in a restorative practice, I get an opportunity to not only hear the offender's experience, but also to talk about my experience, to begin to unload my truth, to begin to unload the emotional burden that I have experienced, to begin to be able to regain some sense of empowerment. And there's an argument that crime, because it affects the public at large, the community, there are lots and lots of people in the community who are carrying baggage that they need not carry as a consequence of crime. A prime example is heightened fear of crime or changes in behaviour to avoid somewhere where a crime has occurred. And so the opportunity to sit in a circle with the offender, with the victim, with representatives of the community, and recover a truth that is acceptable to all three, and then to consider what might be done to address the harm, to help to continue the process of unloading the burden of the emotional and psychological trauma that the victim has experienced, and to do that in a manner whereby some of that burden shifts to the offender, who, when all is said and done, is both responsible for the decisions they made and accountable for their wrongdoing and the harm they committed. Thank you, and I hope that sets in place for the rest of our discussion this afternoon.
Thank you, sir. You are within time. I have one query. The victims they feel very hard to sit with the offender or meet the offender or face the offender. And you know, the system which you have in a developed country like US and UK, that is very hard to think about in the Indian scenario. So what is your take on the how to deal with that, or how to break the ice between the offender and the victim, to making them sit together or meet and reconcile the issues? That and we face this problem even in our cases where we have sexual harassment cases in workplace. So how is that possible, that there would be reconciling, or the offender taking the responsibility and facing the victim, and on the other hand, the victim facing the offender?
In my home state, we had, when the restorative practice of family conferencing was introduced, approximately one half, just a little over one half, of family conferences were attended by victims. So one of the key pointers is that victims should have the right to choose, and any program that is formulated, that is implemented, first and foremost must acknowledge that victims have rights and must respect or fulfill those rights, including the right to privacy, the right to choose whether or not to be involved. Of those 50% of conferences where there was a victim, or victim's voice, I should say, it wasn't necessarily the actual victim. In some cases, the victim was represented by an advocate who they chose. So if the victim was a child, it may be a parent or a guardian. If the victim was an adult, let's say an adult victim of a sexual offence who didn't want, because of her current current emotional and psychological state, wasn't ready yet to be in a conference, then the Victim Support Service, the non-government organisation, or in some cases, myself as the Commissioner for Victims' Rights would attend. In the National Redress Scheme that we have created in Australia for adult survivors of childhood sexual abuse in institutions, such as in mosques or in churches or in temples and other places of worship or in schools. Under that National Redress Scheme, the emphasis is not on individual responsibility, because often the individual is deceased or there isn't enough evidence to bring the individual before a formal structure. The emphasis is on the failing of the institution to protect the person and the institution's role in bringing the victim, the child victim, and the abuser, the sexual abuser in all of these cases, together. Now, under that scheme, the redress includes a financial payment, and the sum of that payment is set in law, but it's based on a decision made by an independent decision maker, like a judge. That's my role during the daytime part-time. The other is that the victim can get psychological assistance to help them navigate the journey towards coping with not only the harm that was done to them as a child, but the harm that they have now experienced by having to relive their victimisation. And thirdly, an apology which can be given in person by a representative of the institution that was the wrongdoer. So in some circumstances, you can have a restorative practice that allows for a victim's voice without an actual victim being present, but allowing the victim to choose who would be his or her advocate, and in some situations, having an authority that can step in to ensure that that victim's voice is presented. And as another restorative practice, where you are looking at a more communal responsibility for the harm that has been done, that is an institutional responsibility, then having a representative of that institution available to meet with the victim and offer. And this is the key issue. What is offered in that circumstance must be a genuine apology, not a half-baked apology, not an apology that has no sense of genuine acknowledgement and recognition. So recognition of the person as a victim, survivor, and acknowledgement of the harm that has been done and the failings of whoever was the wrongdoing or wrongdoer. So in my humble view, there are answers in practice and research to show that some of those answers work for some victims some of the time. Please do not leave today's seminar thinking that restorative justice is an alternative for all victims. It's not. Thank you.
Thank you, sir. Thank you for this answer. I will look forward for more questions and answer from you. Now I would call upon our second speaker, Professor Sarah A. Simmons, member at large, World Society of Victimology. Professor Simmons is an executive committee member of World Society of Victimology and a chairperson of All Africa Criminal Justice Society. For over 35 years, she has worked on victim support interventions in criminal justice system in 17 countries across 4 continents. Her professional engagements as part of expert team has included breaking new grounds to sow academic seeds in social science discipline relatively new to the Eastern African region, such as forensic psychology, victimology, forensic criminology, and family medicine. Professor Simmons' MPhil thesis titled Analysis of Maritime Piracy in Eastern Africa between 2000 and 2010, and she impacted on sea affairs occupational risk perception, became a pioneer work on victim impact assessment of piracy on ship crewing professionals. Her research interest includes African indigenous victimology, human rights advocacy for vulnerable groups, the empowerment of women and girls, forensic criminology, etc., where she adopted a humanistic victimology approach for focusing on strengthening victim assistance strategies and operational capabilities in Africa, often in a volatile resource constraint and high risk context. Ma'am, over to you. 10 minutes time, ma'am, please. You are not audible, ma'am. Okay. Professor Simon, you are not audible. We are able to view your presentation, but you are okay.
Just a minute, please.
Okay. Your presentation.
Okay, I have unmuted myself. Can you hear me now?
Yes, ma'am. Yes.
Okay, thank you very much for that introduction. My presentation is going to seek in the next few minutes to be able to give you a perspective of what existed in Africa before the imposition of Western modes of dispute resolution. I feel that that background is really important because I don't assume that everyone in the audience understands African culture. So in talking about this particular presentation about community-based restorative justice, I'm very cognizant about the different debates and different perspectives. So what I would like to the audience to leave here is with an understanding that before the advent of Western criminal justice systems, we did have a very solid and self-sustaining community in which we lived out victim empowerment. So victim empowerment was the basis of our culture's ritual practices was to ensure that we have a responsible society. Therefore, victimization was considered as a breach of peace, peace among individuals, peace in society. And I thank you, Dr. Kavita, for mentioning the 5 R's of restorative justice because they undergird our cultures. We had a relationship between people of different ages. We had a way in which we related to each other. And that way we related with each other, right from cradle to grave, was to ensure that one grew up knowing at every stage of life what was expected of them. And therefore, the young learned from the old through stories, through rituals, through poems, through proverbs that were intended to teach the young and reinforce to the older ones the fact that victimizing one individual is victimizing community. Now, this is what was thrown out or sidestepped when Western culture was introduced. But it's a very rich form of knowledge on restorative justice. We were based, as Dr. Kavita said earlier, on a relationship between individuals, between the individuals and the community. And if the individual fails to listen to that, we did have sending people in exile, sending them away. So we were relational. And therefore, victim empowerment was socially constructed within the community. It was socially constructed in a way that the individuals related to those of their age mate, their children, their elders, and that was very important because when we look at harms or do no harm, that modern adage is actually a theme that runs through all our themes, all our cultures, all our stories. We are a caring community. The community gives you a sense of belonging. Therefore, if someone wrongs an individual, a family member, they've wronged the community. And that's why it is important that one be able to share and understand that our ancestors and our elders played a very important role. This is a bit that a structure that has been sidestepped by the advent of Western culture. And therefore, when we look at restorative justice, what was being restored in this caring community? What was being restored was what was lost. In committing a crime, one wronged the whole community. One broke relationship with the others. As the late Desmond Tutu said, restorative justice in Africa says, no, the offense affected relationship. And what you are seeking now is to restore that relationship and to heal it. And in so doing, I reiterate the importance of African culture, but also I showcase some places in which it's being used. How is it restorative? How are our cultural practices restorative? They aim at repairing broken relationships, but most importantly, the victim is involved. The victim is given agency. The victim with an S at the end, because in restoring the relationship, you are the wrongdoer and their clan and their community would need to make amends and apologize to the offended community, because the individual's age mates, their family, their clan were injured by that one or multiple acts, whether the individual was alive or not. And so that is being carried out and being reiterated in a number of practices now in Africa. And you can refer to that particular article I've shown, where African indigenous restorative justice is now being used in Africa because of the many conflicts we are having and because of the failure of the Western system of justice to satisfy what we understand as justice. We have the Quifon in Western Africa, Cameroon. We have the Gechacha, which many of you may have read about, that was used in post-genocide Rwanda. And as many of you may know, it's also been used now in Southern Sudan to try and breach peace. We also have it among the Gada system of the Oromo in Ethiopia. So in summary, I'm saying that there are current criminal justice restorative justice approaches being used, but unfortunately, none of it is being attributed to its source. Whether it is among the Aborigines of Australia or among in Africa or in Southern America, this is where restorative justice was birthed. And we have a rich source of information or principles in which that can be unpacked. So I thank you very much, and I refer you to this particular book, those who want to read later, to get more details about how restorative justice and Ubuntu perspective on restorative justice is being used in different parts of Africa. Thank you very much, Dr. Kavita.
Thank you, ma'am. You are on time. I completely agree with you that every country in its rich cultural jurisprudence, they have imbibed a system of restorative justice. But unfortunately, due to colonialization and having a Western impact on the system, we have actually lost it. Just to comment and add on to it, like in our Gandhian principle, we had the concept of forgiveness. But in the current criminal justice system, it is so rigorous and it is so time consuming that we have ultimately done away with that forgiveness, or practice of ahimsa, which which was there in the Indian jurisprudence. So now I will just will look forward for more questions and comments. Now I would call upon our third speaker, our own Professor Dr. M. Madhava Soma Sundaram. Professor is the head of the Department of Criminology and Criminal Justice at Manonmaniam Sundaram University, Tirunelveli, Tamil Nadu. Professor Madhav also holds many prestigious assignments in India for advanced research in criminal law, criminal justice, and as a Vice President of Indian Society of Victimology, President of Criminal Justice Forum, Chairman of Indian Society of Criminology, Journal Secretary of Indian Journal of Criminology, and a life member of Madras Psychology Society and Indian Association of Applied Psychology. Earlier to the present position, Professor Madhava had served as a head of the Division Training, National Institute of Social Defense, Ministry of Social Justice and Empowerment, Government of India, New Delhi, and was in charge of training and social defense personnel in whole of India. Prior to that, Professor Madhava was also a Deputy Director, Academics, Regional Institute of Correctional Administration, South India, and lecturer in Criminology, Regional Institute of Correctional Administration, Vellore. He has also been an invited member of and consultant for various committees, training programs, government projects, periodical reports, and discussion panel. Professor Madhav has authored over 75 books, chapters, monographs, editorials, and peer-reviewed articles on issues relating to victimology, human rights, juvenile justice research and training, penology and correctional administration, police and criminal justice studies. In recognition of his contribution in the growth of criminology and victimology in India, Professor Madhav has been facilitated with numerous awards, including the prestigious Professor S.S. Srivastava Award in 2009 and Professor K. Chukanangam Award in 2015. Over to you, sir.
The moderator of the session, Dr. Kavita Singh, my co-panelists, Civil Society of Victimology, Secretary General Michael, Professor Michael O'Connor, Professor Sarah A. Simpson from the Royal Society of Victimology, and the participants of this colloquium, the first colloquium on victimology. I should really thank my friend, Dr. G.S. Rajpai, the Vice Chancellor of RGNUL, for organizing this colloquium, which will put a face on the restorative justice and what we probably want in this country. So that way, I think I should thank the Vice Chancellor for that. Ladies and gentlemen, the concept of justice and the concept of how it is being dispensed has always been changing over the centuries, maybe 2-3 centuries, it keeps rebooting itself. Our understanding of contribution, our understanding of reformation, and today we speak in terms of restorative justice. But the system that we follow in our country basically keeps or focuses punishment as a main idea. That is what we have here. But is it the existing justice system, its protocols actually focuses on that? 3 people, I think, really contributed in making a paradigm shift in this outlook of punishment. The punishment was bequeathed to us by the classical school, by Bentham and Beccaria. Restorative concept was brought in by 3 people, Albert Rejush, Randers, who very clearly said with 5 words that justice is more than noble. That itself is what he gives you a lot of 3 other conditions, but Randers' principle starts with the 5 words that justice is more than law breaking, and of course, Howard who asked 3 questions which reformatted the way in which we discuss justice. That is basically the issue. Now we have that system. But is it a new system as far as India is concerned? Like how my previous speaker was telling what is happening in South Africa. We also had a system where the system respected the offender, the victim. it took the responsibility of dispensing the justice, and there was relationship maintained throughout the process. I'm speaking of the panchayat system that we always had in India. Whichever part of the geography that you look at, whether it is the north, south, east, west, or even the northeast, you will see that we always had a panchayat system which took care of our issues connected with the criminal justice. Now, with the advent of the Britishers, when they came into the country, they were not able to understand this concept of karuna, or concern, or or forgiveness, and they brought us a system which is basically adversarial, which sort of suddenly became third person and passive. The language that we use, is third person and passive voice. That is what happens. We say in a change hall, right? We say in a police station, say everything becomes informal. Having said that, our panchayat system has been forgotten. We use, of course. There are certain pockets which are there still in our criminal justice system where restorative justice system is practiced. Like, for example, the Constitution provides for the Nyaya Panchayats, or like the moderator was telling to tell us, the Juvenile Justice Care and Protection of Children Act 2015 provides section 18 where, you can send the child to community service order under proper supervision. Or, the civil jurisdictions like, family matters where we can actually work within the existing system. Certain principles of the restorative justice can be taken care of. Also, if you look at section 265A of the CRPC, which actually talks about Deya payment in the chapter 21, that also actually contributes to the practice of restorative justice. But I think there is a conceptual difference between restorative justice per se and the mediation that we sometimes mistake for restorative justice. Now, if you look at very carefully the contributions of Overture or the basic principles which the moderator was also trying to tell us at the beginning of this session, RJ, restorative justice, focuses on repairing the harm. That's all. It is not interested in anything else. You will have to repair the harm. The victim has gone through a process of psychological breakdown, financial, sociological, whatever impact that the victim has found, gone through. This harm has to be, that is the entire focus of the restorative justice process. But whereas the mediation or the alternate dispute resolutions, which we think in terms of, basically looks at conflict resolution. I think addressing the harm is a bigger issue when compared to resolving the conflict. Resolving the conflict may probably settle that single issue, but it is not going to help the community in the longer run because the cause of crime continues to be there, which keeps on producing victims because the causes are always there. This is something conceptually I thought that we will have to remember at the back of our cognitive map when we discuss restorative justice. And do we have a system like that in our? We have a long way to go. Now, if you look at the different types of jurisprudence across the world and the different types that is available for the restorative justice, we have got about 4 or 5 types which are very good. One of the oldest model is the victim offender mediation, as they call it, where the victim, the offender, and the facilitator sit together, and they focus on the repairing the harm, and in the process also make some reparations, something from the offender towards the victim. We have the family group conferencing where the entire family takes part. It sort of gives an increased understanding of the impact that the victim has taken. Community Justice Forum is another form of restorative justice, which some jurisprudence across the world practice. and where the family and the community take a upper hand and they have an increased role. And the other concept is, even though the direct victim and his offender are not present, the victim impact panels, VIPs as they call it, in some places, groups of offenders are addressed by 4 or 5 victims, not necessarily their own offenders, but they talk about the impact which sort of opens new vistas to the participants into the program. What is the impact that the victim has gone through by being a victim? And offenders also understand what is the impact of it. Having said this, how are we going to integrate the restorative justice process, which plays a very important role in the community? We need to prepare the community for that. We need to prepare the agents of the criminal justice system as we have today. More importantly, the criminal justice professionals like the judges and the advocates, that we will have to repeatedly tell them this process probably really assists the victim. And if the victim is not satisfied in any system which is not contributing towards it, the system has got no place. We need to repeatedly hammer it. Then, how are we going to integrate it into the existing system? Are we going to integrate it into the existing system, or are we going to reboot the system from the beginning? Something which we do. To start with, probably we will have to look at developing some sort of a policy. What we have, our islands of excellence in restorative justice in certain sections and certain statutes in our country is good to begin with, but we do need a policy. And we also need some sort of, what shall I say, an accountability, so that you have a rollout program, maybe 2 years, 3 years, where you sort of identify certain cases where you will be able to really help the victim and reduce the impact that is possible. That is happening to him or probably. Then in India, if you think of, suddenly bringing out a new policy, and if you want to implement it, we normally think in terms of a special purpose vehicle, SPV as we call it. SPV is a smaller unit of the bigger criminal justice system, which has got the finances, the fundraising capability, and the key stakeholders participating in it, so that, and they also have the accountability to implement the process. Maybe you will have to think of which type of restorative justice probably helps with the younger offenders, which type actually helps with women. Maybe we will have to do a little bit of research, but definitely, I think if we go in that direction, I think we will be able to take it to the next level, and we can call ourselves as a country which has really tried restorative justice system, which is one of the oldest methods which we have been practicing before the Britishers came to India. And we will have to reinvent it, we will have to implement it, and then I think we will be able to talk more about the restorative justice. Thank you for the opportunity provided and the patient listening. Thank you.
Thank you, sir. Thank for giving such informative information relating to, we had the system in place, which we were talking about the panchayats. Similarly, Constitution also has provision of Nyaya panchayats in place, but we are not using it currently, though in South India, some states are using it. West Bengal had come up with a bill which was not opposed by the lawyers at large in particular, because they are the one of the stakeholders of the criminal justice system. And finally, it did not find shape and place. So if we talk about, you rightly said that mediation is different from restorative justice, because in mediation centers, it is just the two parties are brought together to resolve their conflict. Nothing restoring the position prior to the crime or offense which has been committed on the victim, that position does not take place in mediation. With regard to accountability, sir, I wanted to ask you one question in this regard, that how, in a criminal justice system, the offenders really don't want to take their responsibility. And in no way we can fix or force the offender to take the responsibility. And therefore, we resort to the punishment system which we have, incarcerating them. And rather, if they are released on community-based services, there are instances where we find that abuse are more sometimes with that regard. So what is your take on that, sir?
Any system which is whether it is properly implemented, that it gives you the results. If it is not properly implemented, for example, the community service orders, if it is properly implemented, then probably it is likely to give the results. But if it is not properly implemented, why is it not properly implemented? Basically, because you don't have a you have an opportunity to pivot in a few sections, in a few statutes, but otherwise you really don't have the rigorous tested evidence. The other thing is our offenders are not ready for restorative justice. They are not ready for punishment workshops. You look at it very carefully in the Indian penal came into existence. They are not ready for the punishment workshop. Actually, we don't know whether they are ready or not. Unless and until on a trial basis, we try it in a few cases, not focusing on mediation, but on harm reduction, on addressing the harm by victims. Unless we try it in a few jurisdictions to start with, we actually don't have the data to come to a conclusion whether they like it or whether they don't. I have a feeling if properly implemented, there is a big possibility they will like it. If you talk to the prisoners inside the church, which I have been doing for almost 9 years, when I was teaching the international administrators, I have found that there is always a feeling component involved with every offender, which he is not able to address. And you don't have many number of psychologists also in such things. So this probably will give the opportunity for them to prove this my feeling that I don't have the data to prove it. Probably to start working on two jurisdictions, then probably we will be able to make some grand conclusions.
Sir, there's one question on this Nyay Panchayat. How Nyay Panchayat and Khap Panchayat renders restorative justice? Question from Nandini.
I was not telling that Nyay Panchayat is actually a substitute for restorative justice. I understand that the constitutional framework provides for an opportunity for practicing some of the things. That's what I said. Khap Panchayat, I am not very sure because Khap Panchayat today has got a different meaning. Probably they cause more crimes than settled victims. I am not very sure about it. At least top panchayats are not happening here in this part of the world. Having said that, I feel that if really the panchayat system, if you analyze the panchayat systems which was in vogue 500, 600 years ago, at least in this part of the country, Andhra, Kerala, Karnataka, Tamil Nadu, Telangana region, you will find that when the panchayat sits for a discussion, with the offender and the victim, the entire village, which is what we mean by community today, is also there. And the point is, unless the matter is settled to the satisfaction of the victim, the offender, and the community, they will not be able to go home. Even if it takes 78 hours, they will have to sit there, slog with the case, and they will have to come with a satisfactory understanding of how the repair can be. So I think this is a wonderful system we originally had. Whether Nyay Panchayat will be able to do it, I don't know. I don't have the data.
So from there, I have another question from Mary Sport. How plea bargaining takes care of restorative justice of crime victims?
See, the original objective of the criminal justice system, many times we think that it is the satisfaction of the victim. Yes, the satisfaction of the victim plays a very, very important role. But if you have a system which is inhumane to the offender, the system is not going to work out in the long run. finally, the satisfaction of the victim and the satisfaction of the offender has to come into this. Now, if you are going to give a punishment to an offender and send him to a jail where probably he gets more corrupted than originally he was, the system is not going to be helpful, it is going to be a failure system. So there, I think we are bargaining as a whole.
Thank you, sir. Now we have one question for the Professor Michael. How do victims' lawyer play a vital role in comparison to the prosecutors? In India, we have victim lawyer victims' participation through lawyer only in cases relating to crime against women. In other cases, we don't have. With regard to children, crime against children, where we have only relating to women, crime against women and children in particular. So this question is how a victim's lawyer play a vital role in comparison to prosecutors. If you could, I have seen you have little answered it. If you can elaborate on it, sir.
Thank you. The answer to that question depends in part on whether I should say, where in the criminal justice process the program exists. For example, and this follows on from the answer that was just given on plea bargaining. In the youth justice system in South Australia, the law prescribes what type of offence can be heard before a family conference when a young offender is involved, and sex offences are included, and that those sex offences are child on child as well as child offender on adult victim. The law also provides that the offender must plead guilty, and there is finally a right of the state as a prosecutor to veto the law and put a matter where it believes it's necessary, for instance, to maintain public confidence in the system, to put a matter before the youth court. In that process, the victim has very little role until a family conference is to be convened, and then the victim is invited to participate in that process. That is despite the fact that the Declaration on Victims' Rights in South Australia says that a victim should be consulted on a charge bargain decision. We don't have plea bargaining in our law, but charge bargain decision. For example, to accept a plea to a lesser charge, to withdraw a prosecution, to withdraw completely, or to withdraw a prosecution for an alternative means or process. And the interesting thing in terms of equity is that the state is represented by a lawyer as a prosecutor, and often the accused person is represented by a lawyer in youth justice, where the matter is going to go to a youth court, or in all adult matters, then usually the accused has a lawyer representing him or her. But the victim is expected to participate in the decision-making process around the charge bargain as a layperson with very little legal knowledge, and they can often be baffled. They can often find the conversation very much daunting, and so giving them a lawyer who can assist them to interpret and understand what is being said and to express their views is important at that point. If the restorative process is later, for example, in the sentencing process, then often in South Australia, whether it be a youth court or an adult criminal court, victims will make a victim impact statement, and there's a preference given to victims using their own words and writing their own statement. But once again, that gives rise to an issue of equity. For example, a Hindi person who could not speak English, who became a victim of an assault here in South Australia, would be expected to write their victim impact statement in English and to understand the law here and what their entitlements are. So giving them a lawyer to assist them to articulate their view, to write, to participate in a meaningful way is important. And finally, if the restorative practice is post-conviction and pre the release of the offender, so it might be associated with a parole hearing, then our law in South Australia provides that the victim can participate in writing by making a written submission to the parole board or by applying to appear, but they don't have the right to have their own lawyer. But nor does the offender. The offender appears in person. The offender may have submissions in writing from a lawyer, but the offender appears in person. So that the need, and they don't appear together often. And if they do appear together in a proper restorative meeting, then there are no lawyers whatsoever involved. What is involved, or who is involved, are therapists, counsellors, to help prepare both the offender and the victim for the experience they're about to have, which can be emotional and psychologically draining, and to provide assistance for them afterwards. So the short answer to that question is it does depend on where in the process the restorative practice is placed. But in my humble view, victims are disadvantaged at all key decision-making processes, and to empower them, whether it be as a consequence of their legal illiteracy because they're not aware of the system, whether it be due to their cultural differences and the diversity, whether it be due to their language as a barrier, then providing them legal counsel helps make the justice platform more equitable. Thank you.
Thank you, Professor. Actually, we have also introduced in 2018 amendment that during bail hearing also the victim participation is must, and in appellate stage as well, victim participation in cases of crime against women in particular, we have allowed it. So we will have to wait and see for in the long run how it is effective. But you are correct that at all stage victims are in disadvantaged position due to their illiteracy due to not aware about the legal complexities which are there and the procedural complexities which are there. For crime against women, we have some NGOs working supporting the victim. But that is very piecemeal manner, only in few cases of trafficking or sexual offences, or acid attack cases they are supporting. But otherwise, in the other cases, it is seen that they are not so much having benefited out of it. We come to our next question, which is to Professor Sara. How the indigenous system of restorative justice continued in Africa in spite of Western influence of administration of justice?
That's a very good question. And that's a question we've been asking and got a few answers in the last few decades because worldwide, when people look at criminal justice, sometimes they tend to think we are at the same stage of understanding, whereas some of our communities, like here in Africa, we are still maybe second generation who have been influenced or who are answerable to the westernized criminal justice system. But a good majority of people living in Africa actually still believe that the Western criminal justice system isn't doing justice for us. It takes too long. And we have conflicts and chronic conflicts and multiple generations being victimized. So in the last few decades, you find that many countries have created room for indigenous knowledge introduced in the criminal justice system. And I'll give you very briefly 2 examples. For example, when 2 warring communities, because with us there is a conflict at the individual level and at community level. We've had a number of mass victimization events which have meant that before one conflict is resolved, another arises. Secondly, we've also had where the perpetrator may never be found. Look at Joseph Kony of the Lord's Resistance Army. Look at what's happening in Southern Sudan, Sudan, and Central Africa. So therefore, what has happened is in countries creating room for the use of indigenous systems of restorative justice, they broker the peace, but at the same time, they're using a system that people believe in. Because the victims, the community has to believe that justice is being done, not justice seems to be done. Yeah. When it seems to be done, then you find that there are international arrest warrants that are pending until they're cancelled. You also find that within the other community, I talked about restorative justice as community-based because it's in the community, by community members and for the communities. So therefore, it captures indigenous knowledge has been found to, is being revived because it captures our aspirations for peace. At the same time, the peace is brokered in the community. So the perpetrator, as you saw during the Gacaca in Rwanda, perpetrators are brought into the community. The victim can question them. So the victim has a voice. The victim's families have a voice. And therefore they feel that the justice is not beyond their reach across international borders. They participate in it. They see it being done. They hear the voice of the perpetrator apologizing. For us as Africans, that is very important. And I think that's one of the root causes why even the peace, healing, and reconciliation of South Africa revived Ubuntu. We are a people in relationship to others. So what has happened to help indigenous African victimology find place in the modern westernized society is because we have something, and the metaphysical, the beliefs of the people of peace and justice, in some cases, people feel more accountable to the community and to the ancestors rather than the criminal justice system. And I'll put examples in the chat which people can look at. The volatile northern Uganda and southern Sudan, they've introduced rituals like Matoput. I'm a Nilot and I know what that is, but you can read more about it. Secondly, you find in Ethiopia the Gada system. The Oromos and others have always been, they have a system and they respect it. And the whole community holds them accountable, their immediate community around them. So those accountability structures are helpful. In Western Africa, you have the Kwifon. So you find that, in brief, amidst our law schools and Western culture, our law schools are not teaching indigenous African systems, and yet we live at a crossroad where we still have our culture very present with us, cultural beliefs very present with us, and we have the Western system. So we have a blend. We have a blend. Our government in Kenya, for example, in our constitution, allows people to respect the customary law. And the customary law enshrined in that is restoring broken relationships. I'll put a bit more detail and my paper I published in the chat, so anyone who wants to read further. But also you can get my email in case this is an area of interest. It is of interest to me. Thank you very much.
Thank you, Professor Sarah. Now I have 2 questions before we end, that for Professor Madhava. First question is as to what is your opinion relating to victim offender mediation in the right of restorative justice? And the next question is on in case of community-led judicial system, it is very subjective in nature. It will and influenced by stereotypes. How to deal with the limitations which are there in it?
Okay.
This question is from Sir Nandini. I think this question, no, Soumya.
I read it in the chat box also.
Yes.
Now, victim offender mediation, when we talk about victim offender mediation, are we talking at it from the restorative justice perspective? Or are we talking it from the ADR or mediation process perspective? That is a very important question. If it is from the RJ perspective, then the focus is more on reparation and repairing the harm. If you are looking at it from the mediation process, then probably we are only looking at it from the conflict resolution purpose. That is what we have in mind. So that is my question to your first question. The second question is, what will happen, supposing if you have a restorative justice process or a panchayat system, it goes out of hand, they become, biased, they become nepotistic, all that is very much possible. If your procedures are not clear, if your protocols are not well established, tested over a period of time, then it is likely to happen. What is that we are doing with our policing system? What is that which is happening? I come from a family of criminal justice. I have High Court judges in my family. My father was a criminal lawyer for about 35 years. I have gone through this process for the entire life. I have looked at the process from a different angle. I have found out that are we really delivering justice is a question, a big $1 million question that we have. So, if we have the systems, if we have the infrastructure, if we have the protocol in place, I think RJ will be a good process. Maybe we may have to, as we are going to implement it, we may probably have to think temper. A lot of changes must probably we will have to do, but it will be happening. It will definitely be a little better in compared from the victim's perspective. But if we don't, if we just implement it in a haphazard manner, overnight, fly-by-night operation, then probably it will not yield the results that we are expecting.
So the second question is that on the community-based, this, I'll just repeat, sir, what it is. One more question was for you, that is when we are leaving it in the hands of community judicial system, that is Nyaya Panchayat, will it be fraught or subjective verdict influenced by stereotypes? How to deal with the limitations?
If we don't have proper protocols, it will be subjective. If you have a correct protocol, effective methods of implementing it with the required people, training, orientation, and the funds, then probably it will be difficult. It all depends upon how we implement. If we implement it with the feeling that we will have to implement it because we are going to help at least a few lakh people who are waiting in the courts for their justice, then it is very much a possible. Otherwise, like she says, I am also very, very skeptical.
Thank you all, professors, for giving us such a insightful discussion which we had on the topic on community-based restorative justice. In real sense, in Australia, in Africa, in India, we are working towards this having a system, community-based restorative system, but we have to go a long way, finally reaching to our destination, which we aim at. Looking forward to meeting you all again in similar fora. Thank you all for answering all the questions patiently and giving very to the point focused answer of each questions. I just hand over to the organizing team. Shruti, will you take over from here? Thank you all.
Thank you, ma'am. Before I conclude this session, I would like to extend my heartfelt gratitude to the speakers for the day and the moderator for the session. Thank you all. So we'll be meeting for the next session at 2:30. You can stay logged in or you can log in again at 2:20. The link is live. Thank you for joining us. Thank you all.
Thank you. Namaste.
Have a nice day.
Thank you. Thank you.